Even protected speech is not equally permissible in all places and at all places and at all times, especially private property. Nothing in the Constitution requires the government to freely grant to all who wish to exercise their right to free speech on every type of property. Does that answer your question?
It does.
Okay. Public property is not by tradition or designation a form of public communication. So according to Florida Statute 519, that you do not, as long as regulation on speech is reasonable and not to effort to suppress expression merely because public officials oppose their speaker's view. The intended purpose of the park is to
Excuse me, counsel, please don't interrupt.
Okay. The purpose of the park is explicitly for recreational use and not for protesters to protest. It's for like a family place. May I defer to my co-counsel, please?
Yeah.
Your Honors, may it please the Court, my name is Sydney Niskin. When it comes to the case of Shields v. Lakefield, it's not a matter of free speech and whether or not the protesters were speaking out against something that Lakefield disagreed. It's about the matter of inverse condemnation. The government, seeing as Russo Park is private property, the owners of, or Lakefield Corporation, the owners of Russo Park, have the right to regulate all type of activity and things going on there, seeing as they pay the taxes on it, they pay to clean it. And so by the government saying that they won't remove someone from their property is in result almost a form of inverse condemnation because the government is taking control over land that they haven't given compensation for.
Excuse me, counsel, is it the police's duty to remove the protesters?
Yes, Your Honor, I believe it is. We and Lakefield, and as does the law, state that someone's private property, they have the right to regulate what's going on it. So, for instance...
Doesn't the police also have the right to regulate what they choose to do with their power?
Well, yes, the police have certain qualifications they have to follow for the rules that apply, but when it comes to private property and how someone is using land that isn't theirs, it's the owner's decision as to how it's designated.
Excuse me, counsel, is protesting considered a recreational use of the park?
Well, Your Honor, for 40 days, the protesters were on the parkland, and they were allowed to stay there, and no problem had arrived. But after much time, they were staying in one spot. The sanitation workers were able to get there. They were blocking a large part of the land that wasn't. The park was open for recreational use. For family affairs, you could go and play a game of flag football regardless. And to take over an area that isn't yours on private property.
Excuse me, counsel. Are you familiar with the case, Pennsylvania Central Transportation Company versus New York City?
No, Your Honor.
Okay. In the case, it was ruled that if something serves a public purpose and it has public interest, then no taking has occurred. So, how does this apply to your case?
I don't know if it necessarily does, Your Honor, because just as Statute 520 would say, public property that's not by tradition, a designation, a form of public communication may be reserved for its intended purpose. When Russo Park was open, its intended purpose was for recreational use and to supplement the open land that they needed to leave so that they could build higher. But they weren't required to leave this land open for a park. They could have just merely fenced it off as long as they weren't building onto it.
Could the park have served as a public use for the protesters? Therefore, could it be public interest?
Regardless of public interest, Statute 519 would say that even says that time, place, and manner restrictions are permissible in a public forum. This is a private forum, and it's not public land. So the protesters don't necessarily have a right to be on it. They were, Lakefield was kind enough to even allow them to stay for 40 days, seeing as they were disrupting normal sanitation. With that being said, there was no compensation for the government coming in and taking control over their land and how they were going to say it was going to be used.
Excuse me, counsel. Is Are they, to what extent are they actually obligated to compensate, as it was a temporary, time that the protesters were on their land?
Your Honor, I don't know if it necessarily stated how long the protesters were going to be there, but after such over a month of time, it seemed to become more of a growing problem that they gave it a large amount of time to elapse over, and it was becoming more of an affair. Shields Corporation has the right to control who's on its land and what it's being used for. So just as if someone came onto your front lawn and put a tent down and was sleeping there and said, I'm not causing any problems, I don't need to move. Because it's your land and private property, and you can say that your front lawn was left open as recreational use for your family, for your neighborhood kids, the police would be required to remove them because it's private property that they own. The person that set up tent couldn't stay there. If it had been a public park or a public lit piece of land that people were just staying on, the protesters would have been fine to stay. But seeing as it's private property, it's of Russo Park, it's Lakesfield's decision what the land is used for. Freedom of speech is regulated in public or private land, but this isn't a freedom of speech case. No one is objecting to what the protesters have to say. It's disrupting recreational use. May I defer to my co-counsel?
Yeah.
Thank you.
May it please the court, my name is Justin Murray, and I'd like to reserve the rest of our time for the vote.
Your Honor, maybe continue for one more minute.
Sure.
Also, in reference to our case, we would just like to bring forward the Occupy Wall Street case that was happened in 2011, it started in 2011. Zuccotti Park was private property, and anyone has the right to engage in peaceful protest on private sidewalks and things like that. But seeing as it was private property, they were removed. This is a case almost exactly similar in all of the standings as to Lakesfield, and we'd just like to set the precedent. Thank you, Your Honor. We reserve the rest of the time.
Excuse me, counsel. How was it ruled, though, the case?
The case was decided that, well, it was settled in the fact that the protesters were removed by the police enforcement, and 3 different cases were overturned of protesters that tried to move onto the land again.
All right, counsel, you're into your rebuttal.
Thank you.
Okay. Counsel for respondent in the other case.
May it please the court, my name is Jake Leach from Law Firm H. I represent the City of Lakesville and the case of Shields Corporation versus the City of Lakesville. In this case, we ask that this court affirm the lower court's decision in favor of the City of Lakesville due to the fact that the Lakesville Police Department had no legal obligation to remove the protesters from Russo Park. And in fact, had they taken any action, it would have been unconstitutional. To the protesters.
Excuse me, counsel, but isn't it true by not removing the protesters, they were protecting the protesters' First Amendment right?
Yes, Your Honor, it is. The protesters were exercising their First Amendment rights to freedom of speech, and had the Lakesville Police Department removed the protesters, it would have been in direct violation of their right to freedom of speech. Also, the Fourth Amendment to the Constitution dictates that there needs to be probable cause in order for an individual or a group to be placed under arrest. However, there was no probable cause here because, as the Lakesville Police Department noted, the protesters were not violating any of the park's rules.
Excuse me, counsel, are you familiar with the case Adderley versus Florida?
No, Your Honor.
In this case, the court ruled that a private owner of property has the power to preserve the property under its control for use to which it's lawfully dedicated. So, wouldn't the issue of whether the police should have removed the protesters be considered moot, as it was the owner's property, so they had the right to decide?
No, Your Honor. In fact, the Supreme Court case of Marsh versus Alabama ruled that even if private property open for public use, or excuse me, the owners of private property open for public use cannot prevent an individual from exercising their First Amendment rights. As in the case of Marsh versus Alabama, the petitioner had been distributing religious material on private property that had been used for public use, where the owner of the property wanted her to stop, but she refused out, and the police came and arrested her, and she filed suit and obviously won. So in this case, the Shields Corporation will not be able to tell the protesters to leave, and because he would be essentially stripping them of their right to.
Excuse me, counsel, but doesn't a company have the power to preserve the property rights for the property under its control, as stated by the Florida Trespass Statute?
Yes, Your Honor, but not if it directly violates the individual's First Amendment rights. That would actually violate the Ninth Amendment to the Constitution, which states that an individual cannot use their rights to strip someone else of theirs. So essentially, the Shields Corporation cannot use their right to private property to prevent the protesters from exercising their First Amendment right to free speech.
Excuse me, counsel, hypothetically, doesn't a store such as Walmart have the right to remove people from their property? Wouldn't this be the same as the situation?
That would depend on the situation, Your Honor. I believe, as you said, like if Walmart were to remove someone from their property, it would be because they were disturbing the peace mainly. If someone were on the property protesting against Walmart for whatever reason, then no, they would not be able to force anyone to leave. In addition, the Shields Corporation, the Lakesville Police Department cannot be held liable for not taking action, or if there is no probable cause, as was ruled in the case of DeShaney versus Winnebago County. It's a ruling that the police are not liable for anything that happens as a result of them not taking action if there is no probable cause, they have no probable cause to interfere
Excuse me, counsel. Isn't preventing the recreational uses from occurring in the park include preventing normal sanitation from occurring?
That is what the Shields Corporation is claiming, Your Honor, yes. May I defer to my co-counsel?
Okay.
May it please the court, my name is Anthony Palaro. I would like to mention the lack of inverse condemnation in this case because the protesters were on the Shields Corporation's property, but the City of Lakesville Police Department, they did not force them to be there or tell them to be there. They had a right to be there, and the police department had no obligation to move them. So, in the case Agins versus Tiburon, they ruled that if there is no taking, you are not entitled to any compensation or justice. There is no inverse condemnation in this case because the police department had no right to infringe on the protesters' rights. They had no obligation to remove them. The Shields Corporation would have to.
Excuse me, counsel. Why do you state that the Shields Corporation has no right to remove them when they do own the property and have jurisdiction over their own property?
Well, Your Honor, because the Shields Corporation has the right of their property, but their right ends where the protesters' rights begin. So they cannot infringe on their rights if they're not doing anything wrong.
Excuse me, counsel, but weren't they preventing normal sanitation from occurring, therefore, interfering with the intended purpose of the park?
Well, the protesters had a right to be there, and the Shields Corporation had a right to enforce that, but the protesters weren't breaking any laws, so the police department had no jurisdiction over them because they weren't doing anything wrong, so they couldn't warrant arrest.
Counselor, would you like to end your argument or defer to co-counsel?
Yeah, I'd like to end it.
Defer to co-counsel?
Or yeah, I think we'd like to end the argument. Is that it? End it?
Okay, petitioner may approach the stand.
May it appease the court, my name is Justin Burley. I'd like to start out by referencing some of the arguments made by the opposing counsel. The first thing they talked about is that the police department had no legal obligation to remove the protesters from the Shields Corporation's private property. However, the police do have a legal obligation to enforce the laws and to protect the rights of citizens. The Shields Corporation had requested their assistance because they were directly violating their rights on their property and were causing a nuisance, disrupting the recreational usage that was intended for the park, and also even manner regulations like preventing normal sanitation from occurring.
Excuse me, counsel, does protesting fall under its recreational use of the park?
The protesting does not fall under the recreational usage of the park. In the case, it was even stated that the reason that the protesters weren't allowed was because it didn't fall under this, that it was disrupting the recreational usage intended for Russo Park. So it would not be included under the intended usage. Additionally, it stated that the protesting didn't violate any of the park's rules, and although this may be true, it again disrupted the way the park was supposed to be used and manner through
Excuse me, counsel, but wasn't the police department simply protecting the protesters' freedom of expression and freedom of speech?
They may have thought that they were doing so, but as it was private property, the protesters really didn't have a right to freedom of speech on this private property, especially if they were disrupting the way it was supposed to be used, even if it was open to the public and as a public forum, as stated in Florida Statute 518, even protected speech is not equally permissible in all places and at all times, and nothing in the Constitution requires the government freely grant access to all to those who wish to exercise their right to free speech on every type of property without regard to the nature of the property or to the disruption which was definitely being caused, that might be caused by a speaker's activity. This is applicable in both ways, that they can limit the rights, and they were on the property causing disruption, disrupting normal sanitation from occurring, and the recreational use intended for the park on their private property. And then again, this talks about, this addresses the fact that the opposing counsel had brought up that the First Amendment rights were being violated because they really weren't stripping them of their First Amendment rights. If anything, the protesters, after being asked to leave and after the police were asked to remove them, were violating rights by not getting off of their private property and by causing the disruption on the property.
Excuse me, counsel, wasn't the property until for public use?
Yes, but while the property was intended for public use, this does not mean that we can't, according to Florida Statute 519, in a traditional public forum, reasonable content, neutral time, place, or manner restrictions are permissible in a public forum. The manner restriction would be the thing that's enforcing and asking them to leave because they're disrupting the manner in which the park is operating by preventing the normal sanitation from occurring. So, though it was a public property, or not public property, it's private property, but though it was open to the public as a public forum, we still had every right the Shields Corporation did to remove them from the property.
Excuse me, counsel, but taking as occurred if it is a property stripped from its economic benefit, but did this property have economic benefit to lose?
No, the property did not have economic benefit to lose, but we did not really state that the protesters were taking the private property. With all due respect, Your Honor, Though they were using it for uses not intended, we wouldn't say that they themselves were trying to take the property. But we still had every right to remove them from this property. And additionally, the opposing counsel had mentioned that they had a right to be there that we could not infringe upon. But again, Shields did not give anyone the right to use their private property if they were not using it for the intended recreational purposes. And additionally, we were therefore not infringing on the rights of
Excuse me, counsel, where in the
protesters.
case facts does it state the intended recreational uses of the park?
In the second paragraph of the case facts, it says that we're deeply concerned that demonstrators are disrupting the recreational use intended for Russell Park. So the park was intended for recreational use. With that, I'd like to defer to my co-counsel unless you have any other questions. Okay, thank you.
Your Honor, there's no way to say whether or not there was an economic benefit or default based on having the protesters there, seeing as there is not enough information supplied to know whether or not they could have been blocking an area that possibly customers could have gone into this building. The opposing counsel says that there's no legal obligation to remove.
I'm sorry, counsel, your time has elapsed.
Thank you.
The court is now in recess.